So let's end this lesson with two more questions. The first has to do with immunity. How does immunity work in terms of one's Fifth Amendment right not to incriminate yourself?
Immunity is a great question, great issue to raise. That is one circumstance where you have to talk. The idea behind immunity is we give you immunity from prosecution for what you're about to tell us. So once we've told you you will not be prosecuted for what you are about to say, at that point your right to not incriminate yourself goes away because you're not going to incriminate yourself. So with an immunity situation, the prosecutor has to make a determination that what I'm about to hear is important enough for me to say we're not going to hold you responsible for it. But when that happens, you better talk. Usually under those circumstances, you won't just be incriminating yourself, you may well be incriminating someone else, and that's the reason why the prosecutor is more than happy to hear the information you're going to provide.
I think we're all aware of the fact that sometimes police can breathalyze you or take your blood to get evidence. What is my right as under the Fifth Amendment to not have that happen?
Yeah, that's a great issue in terms of breathalyzers and blood draws. There are going to be some circumstances where the blood draw itself is not considered to be a big deal. It may be considered a big deal to you, but we may be under circumstances where one can get a warrant for a blood draw. With respect to the breathalyzer, the way that normally pops up is when someone's stopped for a DUI, they're pulled over. They may have to provide a breath sample, or the situation is that they may not have to provide a breath sample, but the cost of refusing may well be the revocation of their license. So that's an interesting piece of the puzzle where there's certain circumstances where you may not necessarily be guilty of a crime for refusing to provide information, but there may be other civil consequences that come from refusing to provide that information.
I want to ask, you said that you can get a warrant for a blood draw.
Under certain circumstances, yeah, you may be able to get a warrant for a blood draw.
Isn't that incriminating yourself if the blood is going to show something that could lead to, you're going to jail?
Yeah, and here's the issue that we didn't hit, and that is, if we're taking something from you, that's more like a search than it is self-incrimination. Because what we've done is we've taken the blood from you. The blood may incriminate you, but we didn't make you incriminate yourself. All we did was draw the blood. So you can sit there quietly. You can sit there silently. We're just drawing the blood from you. So that's where there's a combo Fourth and Fifth Amendment question. If we can get the warrant to pull the blood from a Fourth Amendment perspective, we haven't violated your search, your right to privacy in terms of search. It triggers the Fifth Amendment question, but the courts take the position, well, yeah, but you already had the blood in you. All we did was search the blood that you had in you. We didn't require that you incriminate yourself. All we did was say, stick your arm out. Now, there are some folks who would say, that's bull, man. But courts have been pretty clear about that. If we can get the warrant, then we're not going to worry terribly much about the Fifth Amendment issue.